Hello, everyone, and welcome to the Employment Law Counselor Podcast. I'm your host, Jeff Stewart, and we're glad you found us. Our goal here at the Employment Law Counselor Podcast is to give you insight into the practical applications of the world of employment law from the view of two seasoned attorneys. Each episode, we focus on one specific issue and explain how you should deal with it and how your company can stay in compliance. Our podcast is not legal advice, but it is a practical discussion between two attorneys that deal with the maze and minefield of labor and employment laws on a daily basis. If you like what you hear, please give us a 5-star review and subscribe so you never miss an episode. Today, we'll be covering what an employer should do when OSHA knocks at your door. I'm thrilled to be joined once again by John Baker, who practices with me at White & Williams out of our Lehigh Valley, Pennsylvania office. How are you doing this morning, John?
I'm doing well. How are you, Jeff?
I'm doing great. Are you excited about today's topic?
I've been waiting long for this. Yes.
I'm sure you have. You love when you get the call that, hey, OSHA's at our door. What do we do? What do we do? So first off, if anybody did not hear our prior episode where John and I talked about some of the basics of OSHA and the reporting requirements, I would highly recommend that you go back and listen to that before this one or after this one, because I think the two episodes together really give you a good handle on how to deal with OSHA issues. But let's jump in. So, John, what should a business do when they get that knock at the door from an OSHA inspector?
The first thing the employer needs to be aware of is that it's likely information has been provided by an employee or a former employee that there is an issue. Obviously, when you have an OSHA inspector at your door, if you are not aware of it, my advice would be to allow the inspector inside, ask the inspector to wait for a few minutes anyway, contact your lawyer or contact the health safety officer in the workplace so that you can get an idea first what the inspector is there for.
Absolutely. And I think it's important to know that many times an inspector will tell you that they're there for just a random visit. But I know in my experiences, and John, maybe you can back me up, there's never truly a random pop-in. They may not want to share with you the exact complaint that they have received, but it is very rare that you would get a true pop-in.
I agree with that. OSHA and its inspectors, they have very little time just to do random situations. They're dealing with millions of violations per year. The only thing that would be close to random is when there is a targeted industry. For example, I recall a situation involving a restaurant in Pennsylvania, and I represented the restaurant. And OSHA did do a random investigation per se. They were just looking for whatever they could find. But it wasn't based on a complaint or anything. It was just a targeted situation.
Now, when an investigator comes, my feeling is they're generally looking for a few different things. The first is whatever the specific complaint issue was, they're obviously going to be looking for that. But they're not going to come in and tell you that, hey, I am looking specifically at the safety guards on machine 3R on that assembly line. But instead, they're going to say, well, I'm going to do a general overview of your entire facility. And they're looking for obvious dangers, common violations. I'll say the most common is extension cords that are a tripping hazard. That's an example of a common violation. And then they'll be looking at the specific complaint, but they don't want to give away what it is they're looking at. Would you agree with that?
I do. OSHA inspections also result in citations for violations that the inspector had no idea existed until the inspector walked in the door. So, for example, if the inspector is there to investigate a tripping hazard, as you said, Jeff, if they see a tripping hazard, they may find something else as they're doing their walkthrough.
Absolutely. Now, let me ask you this. Must an employer give access to an OSHA investigator?
Yes and no. The yes part is ultimately the investigator or the inspector will find his or her way in. The issue is whether the employer wants to request a subpoena. I don't recommend that because the subpoena is always going to get granted. Right away, you've already established a relationship with the inspector that is not a good one. So I always recommend the access be provided.
And I agree with that. I think it is important to provide access. But that being said, it is access with an escort. And my feeling is whoever my safety officer is should be accompanying that OSHA inspector throughout their inspection. And they can take notes, they can do, whatever they like during that time. But I really think it is important to have a company representative with the inspector as they do their walkthrough.
Absolutely. And the employer has that right.
And it's important to know that you have that right.
Yeah, it's quite often that the employers don't know their basic rights with respect to an investigation or an inspection. Certainly having someone accompany the inspector when the inspector is doing a walkthrough is an important one the employer has to preserve.
Yeah, and that's one of the reasons that we've said, first off, if that inspector comes, call your attorney so that they can remind you that you have these rights. But also, and this was something we talked about in our prior episode quite a bit, having a plan before an issue actually occurs, having that safety point person so that okay, this is the person we're going to have deal with these issues is very important.
It's critical. If the employer does not do it right the first time, it could result in citations and penalties that they're not prepared for.
Yeah. And I think that's a nice transition into what kinds of violations or citations can an employer receive? Now, in my experience, and John, you can certainly share yours, if an OSHA inspector is coming into your facility, 9 times out of 10, they will find something. It may not be what they were initially looking for, but they will find something. Would you agree with that?
I do agree. And I also need to emphasize if an inspector is there to investigate item X, they may also find items Y and Z as a result of their inspections.
Absolutely. Now, violations get classified into 4 different categories. And I find them kind of interesting and they have wonderful names. There is the serious violation, which is pretty self explanatory. Then there is the other than serious violation, because they don't want to say it's a minor violation because OSHA doesn't believe in minor safety violations. But let's call it what it is. This is a minor safety violation. Then there's a posting violation, which is kind of its own separate category. Basically, you haven't posted information to employees. And then the final, and the one that you want to stay away from in any way, is a willful or repeated violation. Now we're talking major fines, major issues, etc. So those are the 4 classifications. And I would say, in my experience, most employers, most violations are deemed serious. And sometimes when you are having discussions with OSHA, you may be able to get them to knock it down to an other than serious violation, essentially a minor violation, although they're not crazy about doing that. Do you have any other insight on these classifications of violations that you'd like to share, John?
In my experience, it's common to negotiate violations, as you've indicated, from serious to other than serious. There is a category below other than serious that's called de minimis. It's rarely used. Usually, de minimis is a paperwork violation. Depending on the type of violation it is, with the type of paperwork, it could be other than serious. There's a category of failure to abate, which is when there already has been a citation and an abatement process was started, but the employer did not abate within the time frame that was agreed to. That can be a citation. I would note that it's important, the type of citation, whether it's willful, repeated, serious, other than serious, whatever the classification is, it's important for the employer to know if the employer, for example, bids on public contracts. Well, this information about the employer's record is considered with regard to whether the employer will get the contract. So you have to be aware of what level of violations are acceptable in the bidding process so that your employer can properly negotiate.
Absolutely. One of the reasons for negotiation is that there are fines that are associated with each of these violations. And the fines are not a set number, but instead a range. If you have a serious violation, there is a minimum fine in the year 2022 of $1,036 for one violation, and that fine can go up to $14,502. So that's a large range, obviously, but the important thing is there's that $1,036 minimum, whereas an other than serious violation has the same maximum fine of $14,502, but there doesn't have to be a fine. In other words, there could be a $0 fine for an other than serious violation. So that's one of the reasons you want to be able to negotiate a serious violation down to an other than serious violation to avoid the fine potentially altogether. Now, as I said earlier, you want to stay away from that willful or repeat violations because those have enhanced fines. And when I say enhanced, they are 10 times the fine for a serious violation. So the minimum fine for a willful or repeat violation in 2022 is $10,360. And the maximum fine is $145,027. So we are talking serious dollars. And what's really problematic is if there's an inspection and you get 4 or 5 violations, now you're talking tens of thousands, if not hundreds of thousands of dollars.
Jeff, I would add to this that even if there was one incident in the workplace, and the question was whether it was serious or other than serious, let's suppose it was, access and ingress was affected. There can be sub-citations on a serious citation. So, for example, if the serious citation is access and ingress was affected, that could be a serious violation. Underneath that, you can have a violation for failure to have a policy relating to access and ingress. You can have another sub-citation that you failed to train your employees as to access and ingress. So if an employer out there that's listening thinks, oh, a serious violation, $14,000, I can handle that, there may be subcategories that triples or quadruples that number.
Absolutely. Absolutely. And, we've talked a number of times about, or we've mentioned at least, negotiating these fines and negotiating the violations. And I think there's kind of two areas to that. This is my experience, and this is where I've been successful in negotiating these OSHA violations. And that is, number one, you can address what happened and say either it wasn't a violation or something to that effect. But I find it's actually more successful and I have better results if we acknowledge that there may have been a violation, but we really focus on how we are abating it and ensuring it doesn't happen again, training that has been given or is in process for employees to ensure that this is not an ongoing issue. And I find that if we do that, the inspectors at OSHA are more likely to knock down a serious to an other than serious violation, assuming the company doesn't have a history of a number of past violations. What's your experiences been, John?
Well, the most important part was assuming that there's no past violations. If it's a repeated violation, you got problems, okay? With respect to negotiating, my advice would be, and when I'm acting as an attorney, I try to act this way, in a manner that is cooperative but firm, that is reasonable but firm, and that underscores that one of the missions of the company, of the employer, is to operate in a manner that enhances the health and safety and welfare of the employee. That has to be part of an employer's mission statement. It's almost guaranteed that has to be in there. And the reason is that that's the first thing that OSHA is going to look at. They're going to say, is this an employer that actually takes this issue very seriously? But you can't just have it in the mission statement. You have to show it. So the more work the employer has done to prepare for the eventuality of an incident or a complaint, the better off the employer will be.
And this is where depending on the size of your company, having a safety committee, an employee safety committee where employees can get together and discuss safety issues. And maybe they meet once a month, maybe they meet once a quarter, but have something like that and have minutes so that you're able to show that, hey, this is what's done. And maybe once a quarter, they do a walk around of the entire facility and see if they notice any issues that need to be addressed. I think that's an excellent way that you can be vigilant, but also to document it in case you would run into an OSHA issue where you're able to then show OSHA, this isn't just lip service. We actually do things without an inspector coming out to ensure that we are a safe workplace.
Jeff, that's an excellent idea. I think we should have that here in our little office. I nominate you to be head of the committee.
Absolutely. I will take that on. So, John, as you know, I like to give our listeners a couple of key takeaways from our discussion here today. So why don't you give one of your takeaways for how to deal with an OSHA inspection?
It's important to know that OSHA is not there just seeking to fine a company. OSHA is there with respect to the health and safety of the employee. So the takeaway that I have from this, because we've talked more about numbers here than we had in the previous podcast. We talked about fines and penalties and types of violations. The important thing here is for the employer to demonstrate that it has a relationship with its employees. And it's not just an employer-employee relationship. It's a relationship where the employer owns its responsibility to provide for safety in the workplace and doesn't just, as you said, Jeff, give it lip service. I think that's the most important takeaway. We can talk about citations and penalties and laws and regulations. The best advice that we can always give employers is to try to stay out of trouble before you have to pay the tons of money you have to pay to defend a case. The most important thing is to prevent that. And the best way to do that is, with respect to health and safety, is to take advantage of the opportunities you have, not just with OSHA, but with your attorneys in scoping out a plan.
And I think the takeaway I would give is something that we haven't really talked about here. We mentioned, but we haven't really gotten into detail. And that is most OSHA visits, we said, are not random. They usually come from an employee complaint. And I know it's contrary to human nature, but I would advise employers, don't worry about who made the complaint. Don't try and figure out, who's making this call? And, we got to do something about that. First off, OSHA has anti-retaliation provisions. So if you do retaliate, you're facing a separate lawsuit, separate action, and that's not where you want to be. But second, focus on the problem that's been raised. If there is a specific issue, deal with that issue. Deal with the safety issue, because safety is something we should all be invested in. No one likes to have an inspection, but if it raises things and makes your workplace safer, frankly, it makes you a better workplace. So with that, I want to thank you for joining us on the Employment Law Counselor podcast, where we try to make sense of the world of labor and employment law. On behalf of myself and John Baker, we thank you for listening. Check back with us, as we'll be dropping episodes regularly on a variety of different employment law topics. If you enjoyed this episode, please leave us a 5-star review, tell your friends, and subscribe to the podcast. For more information on this and many other topics, please visit our blog at www.theemploymentcounselor.com. Until next time, stay safe, stay compliant.